Archangel for Truth. And today my recording for you pertains to the Supreme Court's constitutional misinterpretation. Now, I do need to say before we get into this that I am not an attorney and this is not legal advice. This is simply me expressing my own views and opinions and sharing those views with whoever chooses to listen to them. So, with that being said, we're getting to a point in the way things are going within the government and within not just the federal government, but also the states as well. Ultimately, the decisions that we have received down from the Supreme Court, I'm going to say, are 90% wrong. Now, hear me out before you're like, well, this guy's got to be, you've got to be crazy or something. No, listen. By far, the majority of cases that the Supreme Court has ruled upon, you have individual judges within the Supreme Court, Supreme Justices, that disagree with the decision. Now, here's the deal. The Supreme Court, when it makes a decision, and let's say the decision, it comes down to a 5-4 decision. Five justices believe one way, four justices believe another. And you have, we'll say the dissenting judges are the four that ultimately disagree. So, in reality, what you have then is a single justice that has determined the outcome of a decision. Now, doesn't it make sense to you that if a Supreme Court should make a decision about anything that it pertains to our rights and whether a thing is constitutional or not, that there should be a consensus? At least there should be some agreement that would be a greater majority than simply a 5-4 decision. At least from my standpoint, I think that if the Constitution is this plain and easily understood thing, it is a simple document to understand, and we ultimately are only relying upon the Constitution in our interpretation of what is constitutional or not, then it's a relatively easy thing for there to be a consensus. And so the problem is not just that there's an inconsistency, a subjectivity to the decisions that are made by by the Supreme Justices. But ultimately, what ends up happening is the decisions that are made are oftentimes made based upon other misinterpretations made by the Supreme Court. So, for example, they'll decide a decision based upon what they said in another decision before. Now, the problem is, well, what if that decision was wrong then? What do you do then? Well, the problem that we have is, and it's a very rare occasion that the Supreme Court will actually reverse itself. very rare. But the problem we have is that when a decision is made pertaining to the Constitution, pertaining to the law, pertaining to your rights, that, as I said, 90% of the time, and it's probably even more than that, 90% of the time, the Supreme Justices don't even weigh into their decision the impact of unenumerated rights. Well, you're probably asking, if you didn't know what unenumerated rights are, what are unenumerated rights? Well, the Ninth Amendment talks about that, and it says that the enumeration of the Constitution shall not be construed to deny or disparage other rights retained by the people. Well, what are these other rights? That is what are called unenumerated rights. The enumeration pertains to the Constitution. That is the enumeration of, in fact, the Constitution itself, if you really want to think about it. Before the rights within the Constitution were enumerated, what were they? They were also unenumerated rights. There you go. But what the Ninth Amendment says is that these unenumerated rights shall not be denied or disparaged. But here's the problem. If a decision is being made by the Supreme Court, by the Supreme Justices, and they are not making in their determination an impact of understanding, well, how does this impact unenumerated rights, then ultimately what that does is it makes that decision incorrect, because it assumes that there's no unenumerated right there that pertains to whatever decision they're making. But here's the problem, and this is why it is a problem, because the Ninth Amendment also says that these rights are retained by the people. It doesn't say retained by the government. It doesn't say retained by the states. And it doesn't even say retained by the Supreme Court. But the reason why the decisions are ultimately accepted is because of a misinterpretation made by the majority of those within the legal field, if you will. And what that misinterpretation is based upon what John Marshall said in Marbury versus Madison. See, John Marshall was supposed to give this particular individual he was commissioned to basically fill these different judgeship positions. Well, problem is he ran out of time, and ultimately the gentleman that was supposed to get that commission didn't. And so what John Marshall ultimately did is he determined that yes, the guy had the right for the decision, and ultimately what it came down to is John Marshall struck down it was a federal power that was given to the courts as being unconstitutional. Okay. And then um, he had this saying that he made that it was the duty of the courts to interpret law. Now, yes, that's true. But how it's been misinterpreted is the idea that it is only the Supreme Court that makes that determination. And so, therefore, what happens is when the Supreme Court does make a wrongly decided case, wrongly decided decision, who do you go to for your remedy? Who can you go to correct that? Unfortunately, under the current set of circumstances, there are none. So, what John Marshall said, that yes, it is the duty of, under the Constitution, for the Supreme Court to interpret what the law is, it's not the sole duty of the Supreme Court. Because ultimately, what that means is even an unconstitutional ruling by the Supreme Court would be bound by the people. And if that is the case, then ultimately those rights retained by the people are no longer retainable, because now you are able to um, ultimately avoid them or deny or disparage them simply with a ruling made by the Supreme Justices that never even weighed unenumerated rights in their decision as it pertained to whatever it is that they were ultimately deciding. And especially if we weigh into the to that decision that the Supreme Justices disagreed. And so these are just part of the problems. Here's the big kicker, okay? There is a court case which everyone who hears this needs to look up. It's called Wickard versus Philbin. And ultimately, it pertains to the Commerce Clause in the Constitution. And how it, it's just an example how badly the courts have misinterpreted the Constitution. Because if what the Supreme Court decided there is correct, then you ultimately, your rights are secondary to the Commerce Clause. And so ultimately, Wickard versus Philbin is a court case where this man was growing wheat. He didn't buy the wheat, and he wasn't selling the wheat. He was growing it for his own livestock and to feed his own family. But the problem is that the government said, "Hey, um, we are deciding that too much of wheat is being um, produced, and we have determined that we're going to fine you for growing wheat." Think about that. Think about the vegetables you grow in your backyard. And the justification for that, as was determined by the Supreme Court, was that it is because of the Commerce Clause that the government has a right to regulate what things people can or cannot grow. And if the government says you cannot grow this, you cannot grow it. And if the government says you have to grow this, you have to grow it. That's the absurdity of what the Supreme Court did there. Any reasonable person or reasonable individual, even within the legal field, field recognizes that Wickard versus Philbin was a wrongly decided case. But here's the problem. It was used as a justification for the individual mandate that we know as Obamacare. So the problem with Obamacare is not just simply that, you know, it's making sure that people are getting insurance and so forth and having medical care. That's not the problem. The problem is that it is the government basically saying to you that we are forcing you to to purchase something from a private company whether you want it or not. Problem is the question is, do you have a right, a fundamental unenumerated right not to be regulated? Now that's the question. That's the question that the Supreme Court continues to evade, and especially because it doesn't weigh that in. And ultimately, the reason why I say these things is because, you know, the 10th Amendment does say that we have the same powers that are being articulated in as regards to the states. So I recommend that you read the 10th Amendment and take notice of what it says about or to the people, because then you will understand that our power, our sovereignty, exists outside the government, and that our rights, our natural, inalienable, unenumerated rights belong to us. They do not belong to the government, and the government has no right to limit them, has no right to take them away. And ultimately, what they're trying to do via regulation is to do exactly that. So, with that being said, um, I usually end these pretty short, but I went a little bit longer today because I felt this was an important topic. Anyways, please like and share this, and if you have any questions, feel free to ask them, and as long as it's respectful, I'll keep the questions up, or even if even if you disagree, you know, ultimately, as long as you comment in a respectful way, I have no problem with you uh, posting a comment. So with that being said, take care and God bless.